My case study is the town of Greece v. Galloway. It is part of Unit 4 because it addresses how freedom of speech, association, and religion relates to the public sector. This case is highlighted because it specifically addresses an important tenet of the First Amendment, which is the Establishment Clause, and provides some clarity on where the majority of the court falls on this topic. This case originated in the town of Greece, New York. In 1999, the town implemented a prayer at the beginning of town meetings in order to replicate the meaningful prayer practice in state legislatures. The prayer was intended to place board members in a solemn and deliberative frame of mind, and the prayers were given by unpaid volunteers, and the town at no point excluded or denied a would-be prayer giver. The town also allowed the guest clergy the freedom to compose their own devotions with no prior approval or censorship by the town hall. Susan Galloway is the respondent. She was a local community member and said that the prayers offended her and were an affront to the diverse community. After this complaint by Galloway, the town of Greece specifically invited a Jewish layman and chairman of the Baha'i Temple to speak at a town meeting. Because of this prayer practice in the town hall meetings, Susan Galloway sued the town of Greece in the district court for the Western District of New York. The question the district court addressed was, is there an impermissible establishment of religion in the town of Greece's monthly board meetings when they open with a prayer? As we work through the levels of the courts that this case encountered, you will see that the question being addressed becomes more and more amended the higher up the court structure we go. When this case appeared before the United States District Court for the Western District of New York, Susan Galloway argued that the town violated the First Amendment's Establishment Clause by preferring Christians over other prayers and by sponsoring sectarian prayers such as those in Jesus' name. She requested that not that the prayers stop, but that the prayers would only reference a generic God and would not associate with any one specific belief. Upon review, the district court on summary judgment sided with the town of Greece, saying that it found no impermissible preference for Christianity and that the town did not have to search beyond its borders to achieve a minimum level of religious diversity. Also, it rejected the idea that the prayer must be non-sectarian. Just for reference, non-sectarian means not involving or relating to a specific religious sect or political group. In coming to this decision, the district court relied on the case precedent of Marsh v. Chambers. You will see this case referenced throughout the different levels of court opinions, and the interpretation of this case precedent will vary among the courts. At a high level, this case involved opening ceremonial prayers being conducted at the Nebraska State Legislature. There was concern that the conducting of these prayers would signal to the public that the state legislature was aligning itself with Christianity and that taxpayer dollars were going to fund a state-endorsed religion. The outcome of this case supported the prayer practice in the state legislature and established case precedent that prayers do not need to be non-sectarian to be constitutional. The court specifically wrote that as long as the prayer was not exploited to proselytize or advance anyone or to disparage any other faith or belief, then it would be deemed constitutional. The district court relied upon this case precedent when deciding Town of Greece v. Galloway. After receiving this judgment from the district court, Susan Galloway then appealed this case to the Court of Appeals for the Second Circuit. Upon receipt of this case appeal, the Court of Appeals for the Second Circuit determined an iteration of the question to be as follows. Did the Town of Greece's prayer practice violate the Establishment Clause? As part of this question, the Establishment Clause is embedded in the First Amendment, but there is not much case history on how it should be applied to public administration, or what a government can or cannot do with regard to religion and religious activities. After reviewing this case, the Court of Appeals for the Second Circuit reversed the district court's judgment because it determined that the town failed to promote the prayer program to the public and invite ministers from outside its borders, which resulted in consistently Christian ministers and subsequently aligned the town with Christianity. Although the court determined the town was associating itself with Christianity, it surprisingly found no inherent problem with the content of the prayers. The court also relied on the argument that the invitation to prayer made members of the public uncomfortable as they were in an awkward position of either having to join in or not participate, which could have reflected poorly on them in front of board members. Because this setting differed from the state legislature, this prayer practice was unconstitutional in comparison to Marsh v. Chambers. The court considered the totality of the circumstances for this prayer practice, and because of this, ruled the practice unconstitutional. Having received an adverse judgment, the town of Grace now appealed this case to the highest court in the land, the U.S. Supreme Court. The Supreme Court tends to address broader iterations of case questions which address constitutionality. The specific question in this instance was, does the prayer practice in the town of Greece fit within the tradition long followed in Congress and the state legislatures? The broader questions here include the Establishment Clause and how the public sector should conduct itself in order to be compliant. During its review, the U.S. Supreme Court also revisited the case precedent of Marsh v. Chambers. The Supreme Court majority, however, had a different take on the precedent. They argued that Marsh v. Chambers found no First Amendment violation when Nebraska's state legislature was opening with a prayer and paying for that prayer with state funds. They argued that since the framing of the Constitution, legislative prayers, in the ceremonial sense, evoke other elements that are non-religious, such as a just and peaceful society. They even cited to the First Continental Congress relying on opening ceremonial prayers to set the tones for their meetings. Because of this, Marsh was not subjected to any formal tests because the court found that historical precedent supported the legislative prayer practice's constitutionality. Historical precedent played a significant role in allowing for this prayer practice to continue. Although the court did not rely on any formal tests, it is important to note that at the time of this case, the Establishment Clause test was the Lemon test, which states that to survive a challenge for a violation of the Establishment Clause, a government practice must meet three important tenets. First, a governmental practice must have a secular legislative purpose. Second, it must not have a principal or primary effect of either advancing or inhibiting religion. And third, it must not foster an excessive government entanglement with religion. This test from 1971 was supposedly the preeminent Establishment Clause test for government. However, it was dismissed in the case of Marsh and dismissed again in the case of Greece because of the overriding historical precedent. This calls into question then the legal standard which the government must reach to be compliant with the Establishment Clause. It is not particularly clear to government, and it is not even particularly clear to justices on the Supreme Court. Despite the court's heavy reliance on historical precedent, it is important to note that the court caveats its reliance by saying that permitting a practice that could be a constitutional violation simply because it has a historical foundation, in other words, segregation, women's rights, etc., that is not justification. This case precedent is just establishing that for the Establishment Clause specifically, it must be interpreted by reference to historical practices and understanding. Because the framers viewed legislative prayer as a benign acknowledgement of religion on society, this practice of opening board meetings or state legislatures with a ceremonial prayer should be deemed acceptable in this case. The precedent that the majority opinion for the Supreme Court establishes for Marsh, then, is that it is not necessary to define the precise boundary of the Establishment Clause where history shows that the specific practice is permitted. After establishment of the precedent Marsh contributed to this case, the court began to address the respondent's arguments. First, the respondent argued that prayers must be non-sectarian or non-identifiable with any one religion to comply with the Establishment Clause. The Supreme Court rejected this interpretation. It argued that Marsh does not discuss content or neutrality of prayers, and that the government cannot alter or censor prayers, because under this standard, the government would have to review the prayers before they could even be given, and the court does not deem that a role of government in opening ceremonial prayers. Second, First Amendment is not a majority rules. Once a prayer is invited into the public sphere, the government must allow that prayer and the gods of the minister giving the prayer to be referenced. Despite these arguments made by the court does place some constraints on the content of the prayers in order to avoid a slippery slope. They argue that the government must look at the purpose of the prayer, and if it is meant to denigrate nonbelievers, threaten damnation, or preach conversion, then people could argue that the prayer is falling short of its purpose to unite lawmakers in their common effort. But if it is invoking universal themes and tones of peace and justice and respect, then the incorporation of religious traditions into this ceremonial prayer is acceptable. What if a prayer is given and it falls outside the accepted content that the court says? This is a question that could arise. The court would answer this question by saying that one or two bad prayers does not spoil the whole bunch, and absent a pattern of prayers, the court will not recognize a constitutional violation based on the content of a prayer. Secondly, the respondent argued that the town of Grace did not do enough to invite ministers of other faiths outside of its borders. Therefore, the town was predominantly inviting Christian ministers to speak, and this resulted in the town identifying with only one religion. The Supreme Court rejected this argument and said that the town welcomed all ministers. So long as the town maintains a policy of non-discrimination, the Constitution does not require that it search beyond its borders for ministers of different faiths to speak. Lastly, the respondent argued that the setting for the prayer practice, which was in a public town hall meeting, coerces participants and differs greatly from the setting of a state legislature like in Nebraska. The Supreme Court rejected this argument as well. They wrote that this is a fact-sensitive analysis, but the town of Grace did not compel its citizens to engage in religious observance simply because it opened its meetings with a brief, respectful prayer. They argued that the prayer opportunity must be evaluated against the backdrop of historical practice, and the audience for these prayers is lawmakers themselves, not the public. Also, any religious actions that were directed to the audience were directed by ministers, not by lawmakers themselves. The court was sure to point out that there was no religious-based classification made by the town in this case, and that if a religious-based classification were to occur, this would be an unconstitutional practice. Ultimately, in writing for the majority of the U.S. Supreme Court, Justice Kennedy ordered that the Court of Appeals decision be reversed, meaning that the town of Grace's prayer practice was not unconstitutional. The Supreme Court wrote that the prayer has a permissible ceremonial purpose and it is not an unconstitutional establishment of religion. With this decision, there were both concurring and dissenting opinions that followed. I'm not going to delve too deep into the specific justices' concurring and dissenting opinions. However, because this was a highly controversial and highly divided court with a 5-4 decision in favor of Town of Grace, I think it is important to note at a high level each of the justices' driving arguments. The first concurring opinion was filed by Justice Alito. It addressed the principal dissents in Justice Kagan's response. He first argued that there is no historical precedent for the proposition that only generic prayer is allowed, and he also stated that Justice Kagan's dissent can be summarized down to the clerical staff of the town not doing a good enough job rotating ministers and doing searches outside of its borders for ministers of different faiths. He does not deem this a valid argument. Justice Thomas also filed a concurring opinion with the majority court, except his opinion looked at the Establishment Clause and argued that it should be understood as a federalism provision protecting state churches from the establishment of a national religion and not be looked at as a right for the individual. Justice Breyer, on the other hand, filed a dissenting opinion with the majority decision. He concurred with the Court of Appeals logic and believed that the town needed to do more with regard to securing ministers of different beliefs from outside the town's borders in order to not have reoccurring Christian ministers give the opening ceremonial prayer, thus aligning the town with Christianity. Justice Kagan filed the principal dissent on this case decision, and she argued that Marsh v. Chambers in the state legislatures do not need to be a religious-free zone. So she agreed with the Marsh v. Chambers decision. However, she does not see the applicability of that decision to the Town of Grace v. Galloway case. She argues that this case differs because the audience during these prayers were ordinary citizens, and that because the town had reoccurring Christian ministers give the opening prayer, the government was aligning itself with one particular creed, which violates the Establishment Clause. The case of Town of Grace v. Galloway has much significance related to the Establishment Clause and how religion can interact with the public sphere. Its significance can be summarized into 5 major categories: public administration and policy, political, social, economic, and legal. The significance of this case to public administration and policy is twofold. First, there's the allowance of ceremonial and religious prayers in the public sphere, and second, the treatment of religious pluralism by the government is still very unclear. In terms of political significance, the government's role in religion is still very unclear. For instance, should the government be protecting the experiences of minorities, or should it be preventing the curtailing of expressions of majority faith? The majority opinion and the dissents filed in the Town of Grace v. Galloway case starkly disagree. The social significance of this case is that there are deep divisions among the court on what the government is required or even permitted to do to accommodate religious pluralism. And ultimately, the social impact of this case will depend on the diversity and political climate of local jurisdictions. The economic significance of this case is even broader than established in Marsh v. Chambers, where the government has broad discretion to use taxpayer dollars in religious activity. Lastly, the legal significance of this case can be seen through the highly divided court and varying opinions that were filed for this case. There are obviously an array of approaches to address the First Amendment's Establishment Clause, and therefore it is unclear which test or which legal reasoning should prevail in First Amendment cases. This case then lends itself to some questions to consider. First, why do you believe the court relied so heavily on historical precedent? Do you believe this is the best approach for court analysis, or should the court view the Constitution as a living document and assess constitutionality of amendments based on current-day standards? 2. What are your thoughts on the caveat the majority opinion provides with regard to content of prayers? Do you believe this would prevent a slippery slope effect of the government allowing for prayers with any form of religious content? What do you contend is the enforceability of this caveat? And third, do you agree with Justice Kagan's hypotheticals? In what ways are these hypothetical situations similar, and in what ways are they different from the Town of Grace v. Galloway case?